case. Appellant may proceed.
Good morning, Your Honors. May it please the Court. My name is Nick Shanine, and I represent the appellant in this case, the Palm Beach Dermatology Group and PBOA. I would like to save 2 minutes of my time for rebuttal.
I'll try to remind you, but you'll have the clock in front of you.
Thank you, Judge. This is a case with essentially one issue, Your Honors. It's a good one to start the morning with because it's very, very simple in that the facts have been stipulated to, and there is just the one issue that rotates about this whole case, and that is whether or not a claimant in a workers' compensation case can be held to be permanently and totally disabled when none of her physicians have reached maximum medical improvement and none of them have decided a prospective maximum medical improvement. That means that none of the 3 doctors that this claimant had seen were willing to state that she will be at MMI at such a date, and at that time she will have a permanent disability.
I understand your Pensacola firefighters argument. I guess the only thing that concerns me here is a little bit about the applicability of Emmanuel.
Sure.
The trial court, or excuse me, the JCC did not find temporary permanent benefits, so that to me appears to be premature. However, aren't we really talking about the same factual situation here as we were in Emmanuel? A woman or a person that may get better as a result of surgery and is presently, I understand you dispute whether she's totally disabled, but beg that argument.
Sure.
So let's assume she's totally disabled. What is the practical difference between this and Emmanuel?
Your Honor, the issue of temporary permanent total disability, and that, of course, is an interesting mouthful because temporary permanent doesn't make a lot of sense from the outset, but that being put to the side as well, the difference between this case and Emmanuel is very clear in my mind, Your Honor, and that's that in Emmanuel, the claimant, when she was originally determined to be at MMI by her doctor, she was, first of all, she had an MMI date at that time, and the second and most critical distinction is that at that time, her physicians felt that she had received all of the reasonably necessary treatment that would make her better. She had received all of the rehabilitative care. She might receive palliative care in the future, but they did not believe at that point in time that...
They were not recommending any remedial care at that point.
They were not, whereas in this case, and the other cases that distinguish, such as this Court's Rivendell opinion, in this case, the doctors at the present time not only are unwilling to state that she's at MMI, they have specifically said that she will have the opportunity to get better if she undergoes this recommended surgery that the claimant testified she was willing to do.
Okay, is there any effect about the JCC using the word that she may get better? Is that a factual finding that we're kind of looking with here?
I do not believe that that would be determinative of this issue. This Court is referring to whether or not there's competent substantial evidence that the Court can rely on by distinguishing this as a might get better as opposed to a will get better. I don't think any physician will be willing to state that my surgery that I will do on this patient two months from now will work and will make this person better. That's difficult even for the predictive powers of a physician to do.
Okay, aren't we talking the practical effect, though, here of the carriers delaying surgeries and delaying benefits? I'm really, this is a concern.
Sure. I understand Your Honor's concern there, and I believe that the opposite effect is far more likely in the event that this Court elects to allow temporary permanent total disabilities to come the rule of the land. Of course, the legislature has certainly never enacted such a remedy, but if that were to be the case, then claimants would have almost an incentive to, no, don't take care of your surgery now. Wait until 104 weeks. Wait until after 104 weeks. Because if you wait till 112 weeks, we can get your hearing in when you've reached your 104, when I say weeks, Your Honor, of course I mean days. So, I do mean weeks, 104 weeks, when you've exhausted your temporary benefits. After that time, we can get you PTD almost automatically, because you've got a doctor that will do surgery, but he hasn't done it yet. And it creates a very in my mind, dangerous incentive for claimants not to accelerate their medical treatment. And I believe that's precisely what the legislature was hoping would be the effect of their pronouncement that 104 weeks would be the limit in the 1994 amendments to temporary benefits.
Okay, let's at least address, I guess, what the JCC argued and what the other side argued, that somehow there's a difference because this was in Oswald, it was done prior to the 104 weeks, and here it was done after the 104 weeks.
And that is the hat that the JCC below hung her hat on completely. And we believe that that simply makes no reasonable sense based upon this court's opinion in Oswald, but not just Oswald, but each of the 17 cases that this court has decided citing authoritatively Oswald. This court has again and again reaffirmed the principle of Oswald that it is the appropriate remedy for the patient in that situation to have his doctor. This court went out of its way in Oswald to say, we understand that you're in a position where you're not at MMI, but if you even have your doctor say that you will be at MMI at a certain day, and at that point in time, you're going to be permanently and totally disabled, even with the good surgery I'm going to do for you, then the court would have the proper grounding. You have that permanent impairment rating, and that's essential, Your Honors.
Okay. Well, last question I'm going to throw at you.
Sure.
Isn't there something inherently unfair where a person needs surgery, everybody's pretty assured of that. The rehab period after surgery is going to be at least 6 months. Everybody seems to assume that this person is not eligible for benefits during that period of time.
Your Honor, what we're looking for here is not a hard line, but instead a bright line. That if the 104 weeks that the court stated, not the court stated, but the legislature stated as the proper end of temporary benefits isn't 104 weeks, if it's in fact some extra period that will always happen for claimants in this type of situation, then we've lost the intent of the legislature, and we've lost that bright line, and this court would be inviting myriad cases like this one to come up and repeat different factual scenarios which permeate through the cases that have repeatedly attempted to get this court to weigh in on that value, and instead this court has said there's a bright line, and it works to both ways of thinking, that here a person can get a doctor to make that prospective finding and get permanent benefits now instead of having to definitely wait until later. Here's the other case.
Okay, let me ask you one last question.
Sure.
I lied. If we hold that this seeking benefits is premature under Oswald, which is effectively what we're doing if we reverse, would this person be able to go back and make a case for benefits under Emmanuel?
I believe the answer to that question would be no, Your Honor. Of course, this claimant would be able to return on remand and argue at this juncture, this far out from when the merit hearing was in September of 2004, that she is at this point permanently and totally disabled. She is, of course, is free. If you're premature, and perhaps that's the whole point of this, that if we don't have this bright line at 104 weeks, then this court won't know when the claim becomes premature. This is not Emmanuel. Emmanuel had a very specific factual scenario where a person had MMI and then it changed.
Okay, you're down to a minute and a half.
And I will reserve that time for rebuttal. Thank you.
The appellee may proceed.
Morning. My name is Ken Schwartz on behalf of Ms. Mikan, the claimant below, and the appellee. Unlike opposing counsel, I see this as a slightly different issue. I don't see it as whether or not there was a necessity to have a doctor say whether or not there was MMI, because the case Oswald, which we're basically arguing over, clearly says that statutory MMI can support an award of permanent total disability benefits.
Okay, I agree with you. The person is at MMI, but doesn't Oswald and those other cases that we've cited say that you have to have someone that's going to testify that at actual MMI, that the person will have a level, what the impairment level will be after MMI?
That's the issue as I see it, Judge, whether or not there has to be a specific numerical assignment of a permanent impairment rating. Not whether or not total disability will exist after the date of MMI, but whether or not a doctor must specifically say you have X% as your permanent impairment rating.
Well, do we have either in this case? Either an impairment rating or somebody that's saying that she would be permanently disabled after MMI? I don't see we're either one here in the record.
Your Honor, I see the record slightly differently. I see we have an uncontroverted testimony from the expert below based on competent substantial evidence from several doctors that put her at no work status for more than 10 consecutive months, and an opinion that says that because her objective medical findings mandate that this woman have surgery and she continue to stay out of work, she will continue to be on this no work status. She will continue to be totally disabled going forward. And that's a key distinction in Oswald. In the opinion in Oswald...
Counselor, is there anything in the record that says that the doctor is going to, any doctor testified that after the surgery that she was going to be unable to work no matter what the improvement might be expected from the surgery?
There is testimony from one of the doctors, the neurosurgeon involved, that said she will continue to be disabled. She will be out of work from at least 3 to 6 months post-surgery. So in that way, yes.
He didn't say permanently.
He did not say permanently. No, that's correct. But because the claimant, in order to prove that she has prove that she has eligibility for permanent total disability benefits, must prove a catastrophic injury, that's our first step in the analysis. And that is what that testimony speaks to. The claimant did demonstrate to the judge's satisfaction, based on competent substantial evidence, that there was sufficient record evidence to support a catastrophic injury based on her eligibility for Social Security disability benefits, which was the law at the time.
But doesn't Oswald say that the testimony must be that she will be permanently impaired, not temporarily impaired after the surgery, and assign an impairment rating, speculative impairment rating, I think was the language. Isn't that pretty clear from the case?
I find that as an ambiguity in the case, and the way I see it differently, Judge, is that in Judge Padamano's concurrence, he talks about drawing the line between temporary benefits and permanent benefits, and that's the need for assigning the permanent impairment rating. It's to determine whether or not the permanent benefits should be, that was prior to maximum medical improvement. There was neither statutory MMI nor medical MMI per doctor testimony in Oswald. Accordingly, there was still an issue. Is this person entitled to temporary benefits, or is this person entitled to permanent benefits? Once you cross the line after the 104 weeks and you have statutory MMI, or you have a physician, an authorized physician testifying that the person has reached maximum medical improvement from a medical standpoint, then the question becomes, do you get this kind of permanent benefit or that kind of permanent benefit? And that's when you have the requisite testimony from a doctor saying, this person will not be able to return to work. This is a permanent condition.
So your position is a person can have the same condition, but if they move in the 103rd week for impairment benefits, Oswald applies. But if they move in the 105th week, then they're entitled to benefits.
Essentially, Judge, there are bright line tests in workers' comp. It's a statutory animal. When you say at this level something happens, then yes.
I understand the bright line test, but we have the person with the same condition. And depending upon whether they move in the 103rd week and the 105th week, that's your interpretation of Oswald.
My interpretation is that just like if a claimant has an accident and 105 weeks after the initial date of accident, they file their initial petition for benefits, they have gone beyond the statutory period, and they are time barred. If they did it at the 104th week, only 1 week earlier, even though their condition would have been the same, they're not time barred. It's a bright line test that stops at the 104-week mark. It's, in my opinion, just another way that you have to follow the rules of the statute. If you file before you have reached MMI, whether statutory or medical, then you are premature. If you have reached statutory MMI and you have a permanent impairment that will continue after the date of MMI, and you qualify under the catastrophic injury analysis, then you are eligible for PTD. So essentially, gentlemen, as I see it, we're dealing with Oswald, and I do think that Oswald is distinguishable. The judge of compensation claims didn't expressly state it in this regard, but having gone through it afterwards, I think it may have been better to distinguish Oswald by pointing out that Oswald seems to focus on the Social Security disability analysis, saying that they were disappointed with the retrospective focus, saying that it was at odds with the workers' compensation law. What they didn't want to happen is for people to say, we have somebody who has qualified under 440 .0237 for a catastrophic injury by looking backwards and saying this person was disabled totally for a period of 12 months. But now it doesn't really matter what their condition is. Instead, we have to look forward. We have to have permanent disability, a total disability going forward. And that's another key distinguishment here. We have testimony from the, from the doctors stating that Ms. Mikan was going to be in a continued state of total disability for at least 3 to 6 months going forward. And I think that the judge compensation claims recognized that facts like that take Oswald out of applicability, and it made it no longer an issue in this case.
Well, I read the discussion of the Social Security disability benefits a little differently. It seemed to me what the court there was saying was the claimant may be eligible for federal benefits, but that doesn't speak to whether or not the person's eligible for PTD.
Correct. The language in the case says that it is not dispositive on its face.
So the legislature has basically shifted the financial burden by cutting it off at 104 days to the federal government.
Actually, Judge, I read it a little differently than that. The way I see it is that they wanted to say that because of the state saying we want to shift the burden to the federal government whose pockets are deeper, it was a clear indication that that was not to be the test, the determinative test, whether or not the person qualified for Social Security disability. Again, it goes back to that retrospective focus. They wanted to say that if you are disabled going forward, then Florida will be able to say you are qualified under our law for permanent total disability benefits, and our carriers will pay.
And I agree with you, except it's not just disabled, it's permanently disabled. There has to be, and that's how, at least that's how I read the opinion. Right at the end of the majority opinion, they talk about eligibility for the federal benefits does not speak to whether a worker's disability is properly deemed permanent instead of temporary. So that, and they require some sort of a professional opinion with respect to permanent. And I think that, to me, that's what's missing here.
Actually, I see the temporary and permanent line to be before MMI in that case. Again, going back to Judge Padovano's case, I see that distinguishment to be indemnity benefits on up to the 104-week limit. From that point, it becomes permanent, as opposed to income impairment benefits after the 104-week being the temporary and PTD being the permanent. Once you cross that line into MMI, I think that permanency word falls to the wayside, and instead you look to the actual last paragraph of the majority opinion that says to establish entitlement to benefits under the workers' compensation law, it's required that a claimant prove total disability, not permanent total disability, prove total disability on account of an impairment existing after the date of MMI. It doesn't say how long that impairment has to go on. And in fact, there's a statutory mechanism that tells the employer carriers, you have the opportunity to go back before the judge of compensation claims after having performed your statutorily authorized vocational rehabilitation assessment and tell the judge, this person can go back to work. Their total disability was not permanent and we shouldn't have to pay anymore. Please modify your order. That's all authorized by the statute. I think it's clearly contemplated under Oswald, as well as the so-called progeny of policy.
Where in the statute does it specifically say that there are additional temporary benefits available? I mean, that's basically arguing that there are temporary benefits that are available after the 104 weeks. You either have a permanent disability or a temporary disability. And after 104 weeks, the legislature seems to say all you're entitled to is permanent disability.
After 104 weeks, all you're entitled to is your permanent disability. I agree with you.
Don't you have to have some proof that it's permanent, the disability?
You have to have some sort of proof, but we do in this case. We have objective medical findings. What we don't have is a doctor's...
So you're saying the word permanent really doesn't mean permanent?
In many cases, no. Just like the word temporary doesn't necessarily mean temporary. If a person after 103 weeks of receiving temporary benefits drops dead, their benefits were permanent, weren't they? So it's really a semantic distinguishing. If the person has reached their MMI, whether statutory or through medical testimony saying you are at MMI, then at that point a permanent impairment is looked at, and whether you get temporary benefits in the form of income impairment benefits or permanent benefits in the form of PTD, either way, the benefits are permanent, and that's what you get. Thank you, gentlemen.
May it please the court. Permanent does not equal permanent. Total doesn't equal total. This is not statutory interpretation. Statutory interpretation is to find the clear and unambiguous meaning of the statute when, if at all possible. Maximum medical improvement means exactly that. Average weekly wage means exactly that. And permanent total disability is supposed to mean exactly that. That is, as Judge Van Nort was
Yeah, but
pointing out.
we've gotten to Disney World anyway, because now we have statutory MMI. So, you know.
So we're free to go. And as you pointed out, Judge Wolf, the distinction between a person who's had 103 weeks and 105 weeks, that simply doesn't follow Oswald, and it doesn't follow this court's subsequent cases. Rivendell involved a claimant who was 4 years away from her date of accident. She had exhausted her 104 weeks, and this court very much applied Oswald in exactly the way this judge should have applied Oswald. The same thing has happened in the Olmo case. This court has just decided at the end of May, and has just gotten on the Florida Law Weekly. 104 weeks, once it's exhausted, doesn't change a person to, as you point out, going to Disney World for free. Judge Padovano, in his concurring opinion, saw exactly this problem when he said arguably one solution would be to award permanent total disability benefits based on the current degree of impairment and then revisit later. And then he says the weakness in this approach is that it treats what may be a mere temporary disability as a permanent one and extends the payment of benefits beyond the 2-year limit, just as Judge Van Norwick has explained would be the case here. I believe that this case is clear, a reversal is required, and I thank you for your time today.
Thank you. The next case on the docket is Gabriel Dean Walker versus Cash Register